Good morning, everyone. My name is Igel Gledhill, and I'm a physicist and a member of ASAF Council. I've been asked by Council to lay a bit of a foundation on why we are holding this webinar at present. May I welcome everyone who's here? One might say that there's a great deal of interest being taken in this field. In March, Professor Salim Karim was interviewed on Power FM and asked about what was called the dissent in the scientific community. His reply was that diverse views are at the heart of academia and that academia would not function without them. Personally, I've always wondered how on earth ASAF is able to arrive at consensus studies, but I think it's miraculous that it succeeds in doing so. The miracle's performed by finding common goals and a very great deal of hard work. Part of ASAF's role is to seek out issues that are important to science, and I use the word science in the broad sense of the Academy of Sciences, including health, law, humanities, and so on, and allow them to be aired, find the ground that is common, and identify the real bones within the body of contention. It sometimes occurs that difficult concepts can be dissected out and an objective report on their pathology can be obtained. The results, however, open the practical way forward, and that is what this virtual workshop is for, the way forward. So first, why is copyright important? The Copyright Act and the Copyright Amendment Bill are fundamentally important to science in the broad sense and to research. The Act and the Amendment Bill are also fundamental to South Africa, its systems, its economy, and its capacity for innovation. Open science has significant benefits, but these can only be gained if copyright is respected and IP rights are enforceable. Policy will state that it should be as open as possible, as closed as necessary. Similarly, the Copyright Act and the Copyright Amendment Bill are vital in moving not only to the fourth industrial revolution, but into the preceding third industrial revolution, digitalization and data. In climate change and pandemics, the digital economy, the digital education system, and digital aspects of the health system, digital libraries, and digital museum collections are essential. You may not know that digitalization of museum collections is fundamental to understanding climate change. It doesn't take successive lockdowns to show this. The Act and the Bill are supremely important for the way South Africa is seen by international actors. Is it a safe space for the intellectual property of partners in collaboration? Or does it offer a generous buffet of loopholes for international rapacity? Are its indigenous people protected or exploitable? Are treaties respected or disregarded? With importance established, why did ASAF choose to call a workshop on the topic? The motivation for this virtual workshop is that the Copyright Act and the Copyright Amendment Bill are both contentious, and a workshop is a mechanism for seeking ways forward. Then I ask, why the rush, given that this bill has been in the works since 2017? Parliament referred the Copyright Amendment Bill of 2017 to the President for signature on 16th of June 2021, but the President sent the bill back to Parliament citing 6 concerns to be described later. Public comment on that process was opened until the 9th of July 2021. Given the role of copyright in the practice of science, in due acknowledgement in terms of data and digitalization, it's important to address this opportunity. The intention was to put this workshop in place to collect comment to be submitted by ASAF by the 9th of July deadline. As you might know or discover, the bill has since become no longer a national bill, but a bill that must be considered by the provinces and the traditional leaders. The process is known as retagging. It has implications which I hope you will hear today. One of them is that Parliament has stated that it wishes to have the bill finalised by the end of 2021. Constructive submissions within the provinces and Indigenous knowledge systems will be needed. The objectives today are therefore to inform academics and institutions, to hear the issues, to start to formulate comment for July 9th, and to start the process of formulating practical reforms for the bill. We seek a coherent way forward that benefits the many diverse stakeholders: South Africa, science in South Africa, science from South Africa, and science in collaboration with South Africa. What we ask of you, therefore, is, having informed yourself on the issues, not to look back and rehash the arguments, but to apply your considerable ingenuity to solving the issues. Thank you. Richard, back to you. Richard, I think you may be muted.
Sorry, I was still muted. I was saying thank you very much to Professor Gledhill for setting the scene and explaining the reason why ASIF has called, has arranged this webinar. As Professor Gledhill has also explained, President Ramaphosa referred the bill back to Parliament, raising specific, I think it's six grounds on which he believes that the bill is unconstitutional. One of them has been already responded to, as Professor Gledhill has mentioned, and that the bill has now been re-tagged as a provincial bill, and therefore has to go to the National Council of Provinces and be considered by the provinces. So that's going to cause a further delay in getting the bill again passed by Parliament. In the meantime, as Professor Gledhill has also explained, ASIF and other interested parties have to submit their views by the 9th of July, which is next week, notwithstanding the extension that there's bound to be. I should also explain that the submissions that could be made by the 9th of July are limited to the issues that have been raised by the President. And therefore, too, the subject matter of this webinar is similarly limited. The procedure will be that we have four presentations following immediately of not more than 15 minutes each, from Sonia Samtani of Oxford University, Professor Keyan Tomaselli of the University of Johannesburg, Professor Klaus Beiter of Northwest University, and finally from Professor Owen. After their presentations, I will invite each of the presenters to make very short comments, if they wish to do so, on what has been stated by the other members of the panel. We will then have a Q&A, and I would invite members of the audience to send questions, preferably to the Q&A function of Zoom at the bottom of your screen, or if you wish to speak, you can raise your hand, and I understand that you will be unmuted and will be able to put your question to the panel or to individual panelists. At the end of the Q&A, the webinar will conclude with further remarks from Professor Gledhill on the way forward. So what I propose to do is very briefly introduce the panelists now, and avoid interrupting the flow of their presentations. The first panelist is Ms. Sonia Sabatini, who is a doctoral research scholar of the law at the law faculty of the University of Oxford. She is there as a Rhodes Scholar. Sanya was also a foreign clerk on the Constitutional Court of South Africa from July to December 2018. She has spoken and written widely on the issue of copyright reform in South Africa in popular media and academic writing. She'll be followed by Professor Keyan Tomaselli, who is a distinguished professor in humanities at the University of Johannesburg and chair of the ASIF Committee on Scholarly Publishing. He's the founder and co-editor of 2 international journals. He will be followed by Professor Klaus Beiter, who is an associate professor of law at Northwest University. Professor Beiter is an affiliated research fellow at the Max Planck Institute for Intellectual Property and Competition Law in Munich, Germany. He teaches intellectual property law, socioeconomic rights, and international social justice. The final member of the panel is Professor Owen Dean, who is perhaps the doyen of copyright lawyers in South Africa. He was, for many years, the senior partner and is presently a consultant of the law firm Spur and Fisher, a leading intellectual property firm of attorneys. Professor Dean served on the South African Government Advisory Committee on Intellectual Property of Law for some 20 years. He was the first incumbent of the Anton Mostert Chair of Intellectual Property Law at Stellenbosch University. Well, there we have it, and it gives me great pleasure now to call on Sonia Sabatini.
Thank you very much, Judge, and morning, everyone. It's wonderful to be here. Just going to share my screen quickly so that you can see my presentation. I just want to check that I'm audible. Can everyone hear me?
Yes, we can.
Fantastic, thank you. Great, and this is my presentation. Can everyone see it?
Yes.
Wonderful, okay. So the title of my presentation now is why the current Copyright Act inhibits education and research specifically, and how the Copyright Amendment Bill fixes it. So for those of you who are here because you saw that I was going to talk about authors and users as constitutional rights bearers, don't worry, I'm still going to talk about that, so you won't be disappointed if you're here for that content. Any conversation about South Africa must start with the idea that South Africa is a constitutional democracy founded on the values of equality, dignity, and freedom. The Constitution itself is intended to be radically transformative and contains a strong Bill of Rights to that end as a cornerstone. So what does that mean? That means that Parliament is specifically obliged to act within the constitutional frame and further rights in the Bill of Rights. So this, of course, applies to Parliament when it passes laws, amongst other functions. Parliament also has a specific duty to bring all pre-1994 laws in line with the Constitution. This, of course, has been the focus of a decades-long movement, which has resulted in the Copyright Amendment Bill. The CAB, which, as I'm going to refer to it, seeks to urgently rectify an unconstitutional status quo created by the Old Order Copyright Act of 1978. Researchers and educators like us are simultaneously authors and users. To create, innovate, and engage in knowledge seeking and knowledge generating, we need access to existing work. Of course, Newton and Pascal were right that we are dwarves that stand on the shoulders of giants. And the Constitution of South Africa recognizes this interconnectedness in several provisions that I'm going to now discuss. First, the Bill of Rights protects academic researchers specifically under the freedom of expression guarantee. It states that everyone has the right to freedom of expression, which includes particularly the freedom to receive or impart information or ideas, and the academic freedom and freedom of scientific research. Second, the Bill of Rights protects all researchers equally because the right to equality undergirds the realization of all other rights and entails that irrespective of race, disability, culture, language, and any other socioeconomic markers, academic researchers must be able to realize their rights without discrimination on any of these grounds, or grounds that are analogous to them. Third, the Bill of Rights protects the right to further education, of course subject to measures that the state takes, of which exceptions and limitations to copyright are some measures, is guaranteed by the Bill of Rights, and specifically to make further education available and accessible. We'll come back to that. Fourth, the right of everyone to participate in and contribute to cultural and linguistic communities and linguistic life is protected by the Bill of Rights. We will also come back to this particular provision. It must be noted that the Copyright Act inhibits the realization of all of these rights in many different ways. Some of this is set out in a joint opinion that I co-authored with a loose coalition of international and South African academics, as well as in my PhD thesis, which will be openly accessible shortly. This joint academic opinion can be found on the InfoJustice website, and Klaus Beiter, who's here, is also one of the co-authors of the opinion. I'm happy to share it with anyone who's interested. So the CAB seeks to rectify this situation for several groups in particular, that is people living with disabilities, people living in poverty, and importantly for today, for academics, researchers, authors, and students. As an academic researcher based at an educational institution myself, I am, as I mentioned previously, simultaneously an author and a user at the same time. I require access to published works to produce my own monograph, for example. The current Copyright Act in South Africa significantly limits such access. So in the rest of the presentation, I will discuss 4 key rights-limiting problems caused by the current Copyright Act. Turning to the first, I focus on how the current Act unfairly discriminates against people living with disabilities, including researchers living with disabilities. The current Copyright Act does not contain any provisions that enable accessible format shifting for people living with disabilities. This is in contrast to over 96 countries in the world and counting that have these provisions, as well as parties to the Marrakesh Treaty to facilitate access to educational and cultural materials for people living with disabilities, who have access to a worldwide accessible network of library materials. The CAB is one of the steps that the Parliament is taking to ratify this particular treaty, and so this provision becomes extremely salient. What does accessible format shifting mean exactly? It entails things like the closed captioning of films, conversion of text to audio, reproduction in large print, for example, which are all technically unlawful under the current regime without seeking express consent from the holder of copyright. What this does is create a situation where even if a license to a particular work is purchased at full price from the market, in order for it to be meaningfully accessible to people across a spectrum of disabilities, there's an additional onerous requirement of actually finding the right holder, asking for permission to convert text to speech or reproduce the work in large print format. This is, as I say, as good as inaccessible for people living with disabilities. Similar issues also arise with, say, for example, the license to use particular works that are tied to specific devices, which ignores the realities of how assistive technologies work and the importance of using the same work across different devices to make more accessible. Frustrated by this book famine, Blind South Africa, representing the interests of visually impaired people across the country, launched litigation not once but twice, highlighting the pressing urgency of their ongoing deprivation that I just described. Retired Constitutional Court Justice Yaqub also filed an affidavit in support of Blind South Africa and has been extremely vocal about this problem. So what does the CAB do to fix this? The CAB explicitly contains a provision to enable such accessible format shifting, which directly rectifies this problem that I have described. The CAB also goes further and contemplates time and device shifting requirements for the meaningful use of assistive technologies as well. In addition to people living with disabilities, universal design in the form of accessible format shifting, time shifting, and device shifting is important to everyone. COVID-19, the pandemic we're all still living through, has thrown the importance of adaptability of works into stark relief. Now, I can give you my own example. When the United Kingdom went into lockdown at the beginning of March 2020, all of the libraries here at the University of Oxford were physically closed, and they stayed shut for almost the entire academic year. That was the year I was writing up my PhD, unfortunately. The Oxford Bodleian libraries are legal deposit libraries, so whenever anything new is published by, say, Oxford University Press, they are bound to deposit a copy. I had the unfortunate requirement of a recent article on COVID-19 itself to aid my research, and the only copy happened to be an electronic legal deposit. So this led to a strange situation where the Bodleian Library had an e-copy of this work, but would not email it to me, because according to copyright law in the United Kingdom, it had to be accessed on a library computer within the library, and the library was shut. So to further heighten the strangeness of this circumstance, the library then started to pay for package subscriptions to publishers who had already deposited the same articles through the scheme, effectively simply buying access to something they already had, simply to make it accessible outside the the library building, but still on its secure server. This is a waste of a library budget, in my opinion. But thankfully, the CAB solves some of these problems through the listed provisions as well. The second problem that I'm going to outline today is that the current Copyright Act simply does not facilitate the use of new technologies. The current act is obsolete as it does not enable the use of more recent text, content, and data mining methodologies for research, and it significantly limits the right to scientific research as discussed previously, which leads to the limitation of innovation. These technologies enable us to synthesize knowledge from existing knowledge that is otherwise not humanly possible to do by using various programs that crawl through literature on a particular issue and help us determine patterns, which could lead to leaps and bounds in scientific research. For example, at the very beginning, Eagle mentioned climate change. So this technology could assist a geographer using this technology to compare photographs of, say, coral reefs over the past 100 years in order to understand the full extent of the climate crisis. In order to use this technology, often incidental copies are required for coding purposes, and the current Copyright Act simply does not contemplate this. It also limits research exceptions somewhat arbitrarily to literary and musical works only, and entirely excludes sound recordings, software, and films from research exceptions. This leads to a slower pace of innovation with regard to those other categories of works, and in my view, simply cannot be justified. In any event, innovation is then confined to the areas that the human eye can read only, rather than making use of recent advancements in technology. How does the CAB fix this? This problem is directly rectified by the CAB because it does not distinguish between categories of works. It simply does away with the distinction. And then what it does is it creates a hybrid model of fair dealing and fair use, which I'm sure we're going to talk a lot about today. It creates an inclusive list. And that's really helpful because what it does is provide illustrations of particular uses that Parliament has legislatively considered to be fair, of which research, scholarship, and teaching are a few. But it's also particularly helpful because the use of such as the inclusiveness of the list means that the CAB is future-proofed. Text, content, and data mining, machine learning technologies, and the use of algorithms, this is all emerging technology that we're yet to unlock the full potential of. And so when we have an inclusive list, that means that when newer technologies emerge to aid innovation, the CAB will not require repeated, lengthy processes of amendments. It must be noted here that this is not a free-for-all that I'm arguing for at all. The only uses that can be included within such an illustrative list are analogous uses rather than random uses, according to canons of legal construction. In any event, it's important to note that copyright does not protect ideas, only expressions of ideas. So it's really important that this particular inclusive list is something that we actually argue for. This is something that the parliamentary submissions explicitly call for, the parliamentary consultation explicitly calls for submissions on. The third problem with the current Copyright Act is that it simply does not enable the preservation of cultural heritage. Current Copyright Act does not contain exceptions to enable the mass digitization of libraries.
Sorry to interrupt, last 1 minute.
Yeah, thank you, Judge. The current Copyright Act simply does not contain exceptions to enable the mass digitization of libraries, archives, museums, and galleries, and contains very limited regulations that deal with the making of copies, uses words like facsimiles, which, let's be honest, no one uses anymore. But I must conclude by saying that in the fire that ravaged UCT's rare African Studies collection, there was massive damage caused not only to the library building, but also to the rare manuscripts inside UCT. And that's partly because the current copyright regime simply did not allow for the digitization, did not clearly allow for the digitization of various collections. So the current Copyright Amendment Bill, in fact, fixes this problem by containing detailed exceptions for libraries, archives, museums, and galleries, and enables the realizations of the rights to education, participation in cultural life, scientific and academic research, and free flow of information through dedicated provisions, and would rectify this problem. So it might be too late for the African Studies collection, but it's not too late to do this for the other libraries if the CAB is passed. Finally, moving to the final points, because I am running out of time. This is what I initially said to speak about, that the current Copyright Act does not distinguish between authors and intermediaries. It does not take into account the fact that academics contribute to journals without any payment, and libraries have to buy back research from their own staff, and does not account for authors as users. But what the CAB does is the CAB specifically enables institutional repository, something we're all familiar with. It allows for theses by publication, the use of published works for academic assignments. It makes publicly funded research publicly accessible, and specifically introduces a reasonableness requirement within licenses. In conclusion, the CAB is important because it realizes users' and authors' constitutional rights. Without the CAB, we would all remain in an unconstitutional and obsolete status quo. Thank you very much.
Thank you very much indeed for that presentation, Ms. Samtani. And now over to you, Professor Tomaselli.
Thank you. Okay, I'm speaking as a practicing academic occupying an office either at my university or at home, who has to negotiate the kinds of impacts that this bill will have on our daily work, performance assessment, research funding, et cetera, et cetera. So I'm going to take a slightly more general perspective and then home in onto the specific. So firstly, intellectual property rights as a modus for wealth creation are being transferred, as we've heard, onto previously unvalorized sectors of the market: cultural forms, fabric designs, folklore, knowledge of natural resources, dance steps, and so on. And as such, intellectual property rights are central for the development and innovation in the fourth industrial revolution, information-led economies. Weak copyright protection, however, disincentivizes the creation of new and original content. So my concern thus relates firstly to the potential impact of the bill on national research, creative, and the publishing economy, and secondly, the allocation and management of research and publication resources and rewards within universities themselves. The intricate complexities of the value chain remain largely hidden, a largely hidden transcript in our day-to-day work. That's why getting to grips with the implications of the bill at the coalface are often so difficult. My conclusion is that a significant proportion of the Department of Higher Education and Training publishing incentive that currently finances research activities would be rerouted to meet publication costs. Question is, are our institutions ready for this impending sea change? The bill broadens the Act's numerous exceptions such that unauthorized, unpaid, and even unacknowledged use of an author's work is permitted if it is for education, an undefined purpose wide open to misinterpretation. And noting that the first and third speaker were co-authors of an opinion promoting the bill, as we were shown, subject to certain conditions, will proponents of the bill in the upcoming parliamentary session also propose the retention of moral rights in the fair use clause? The academic need for citation practice is a key component of variability in the scholarly project, and I will return to this below. The pro bill argument is that publishers are deliberately impoverishing students, so in effect the solution is to enlist educational authors and their publishers to cover state funding shortfalls by tolerating unrestricted copying of printed materials. Currently, a system of permanent identifiers helps to manage this, but the proposed bill might undermine such mechanisms. But we are rhetorically told that all will be well because information freedom and information justice will be obtained. In turn, this will stimulate national intellectual innovation and economic growth. In effect, the savings for students will be minimal, about 150 Rand per year per student for a Dalro blanket license. And this saving is unlikely to be passed on to students if the Canadian experience applies. And of course, the publishing industry will contract. And the very wide-ranging definition of fair use on materials to be used for educational purposes is of grave concern to the National Scholarly Book Publishers Forum, itself convened by the Academy of Science. The negative financial implications, as assessed in the PricewaterhouseCoopers analysis, is that the bill's extended version of fair use and its educational exceptions are overbalanced towards users and prejudicial to creators. Since the DTI has not released its own impact assessment report, now an additional study to consider post-pandemic conditions and projections is necessary. And I suggest this awaits ASAF. Now, the fair use exceptions is far more extensive than that of the US when coupled with indiscriminate contract override clause. But with none of the protections like statutory damages that would discourage fair use beyond the limits of fairness. An illustration of the creation, sorry, an illustration is the creation, recreation, and appropriation reported in the Daily Maverick, titled Graham Williams versus Hank Willis Thomas, Acceptable Artistic Appropriation or Plain Old Threat. Now here is the creation by an American artist exhibited in a South African gallery. And here is the original creation created by Graham Williams without reference to his prior work, without consultation with the original artist, and without attribution. So this graphic appropriation without citation, an example of fair use possibly in the US, even as it alienated Williams from the fruits of his labor and his moral rights, and he was not consulted. Now, the educational exceptions in 12D might enable replications in such a case. The question is, to what extent can authors and publishers retain control over the ways that their creations are used? In publishing, local university presses that lack sufficient institutional support will be directly affected. Some might close, merge, and downsize. International publishers partnering with local presses might cease. Full-time educational users, especially of school and university textbooks, could be deprived of royalties, as might African language authors when their books are adopted as class readers, a key market for indigenous language publications. Local textbooks will stall with no sustainable backup plan. Remember, local university presses are inadequately resourced, unlike the international straw men publishers that the bill's proponents have in mind. But this open access argument confuses access with content. Open access, a desirable format, will see a shift from reader pays via libraries and campus bookshops to author pays, which can be prohibitively expensive, especially for emerging humanities and social sciences scholars publishing their first monographs. There is no consensus yet on how to sustainably fund monograph publishing. Economies of scale stretched across tens of thousands of subscribing libraries and millions of readers will be replaced with author pays for readers to read. Under this scenario, funding is flipped as article processing charges will substitute for the cost currently borne by publishers. And big tech companies are indeed eyeing the digital future. The broader the fair use regimes worldwide, the easier it will be for them to appropriate intellectual property. The actually stated intention of big tech is to engage in information prospecting and appropriation. Their argument is that information is then made free to browsers and users, e.g. students, lecturers, searchers. What most sharing sites do, however, is to harvest browser personal data to sell these on to advertisers. The communication channels and associated transactions are thus presented as free to readers. Whichever financial model is at play, however, commodification remains the outcome. Thus, protecting rights is not just the preserve of multinationals. All organizations and individuals, irrespective of their economic status, should be protected. For university administrators, the bill is understood as a matter for the library, or is thought to mainly affect textbook production. However, as the HSRC and Wits University presses have argued, the loss of homegrown textbooks will have implications for the decolonization of curricula, one of the key performance indicators now listed in performance assessment categories in response to the fees must fall movement. The downside will be that we will again, they argue, become reliant on expensive international imports written for the general reader anyway. The bill will also incentivize, they argue, South African academic and non-fiction authors to publish overseas, where their rights would not be subjected to the same restrictions and limitations. Within universities, research funding regimes will be directly impacted. Hefty article processing charges and upfront book publishing subventions will be substituted, as publishers will no longer absorb the risks and costs of publishing, leaving less funding for actual research expenses. This work might be published locally less often. And given that the variable income sourced from research publication from the department to universities is a major factor in South African university financing, this entire system would have to be revisited, re-engineered, and remanaged to try to protect some funding for research expenses over the increased payment for publication purposes. But institutional savings will occur in the short term if the bill is enacted, as libraries will be relieved of course-pack licensing with the closure of copyright offices that currently regulate reproduction of materials for classroom use. Now, here are some broader contradictions. If authors' rights are to be restricted, then how does one separate IPR with square IPR policy with copyright policy? For example, University of KwaZulu-Natal, one amongst many, recognizes the institution as a repository of knowledge. It says generated through research and disseminated through applied research and consulting, teaching, community service, and archiving. This knowledge, UKZN observes, is reflected in IP created in forms such as copyrights, patents, trademarks, designs, trade secrets, and know-how. UKZN insists that IP must be identified and properly managed for mutual benefit of the university's community, the creator thereof, and society in general. In identifying and managing such IP, UKZN will uphold the rights of its IP creators. These will be recognized to further ensure that IP is supportive of the primary function of the university, scholarship and research. Now, if the bill is to be supported by universities, then the contradiction is clear. Universities should also place their patents, software, and inventions into the public domain also, and allow the tech companies to harvest them for their own profits. The transformation is high in the agenda, but emerging academics will be most negatively affected by the author pays model. There's just so much money in the system. There's far more open access money available in Europe and the North than there is locally. And so what is going to happen, I think, is that there's going to be a shaking out of articles that are submitted and fewer will be published. That might be a good thing, but it's also going to have impacts on emergent scholars who are still trying to get into the system. Now, authors write in order to be read so that they authors write to be read so that they tend to support the free flow of information, but not the flow of free information. Reproduction under license is the solution.
So Tomaselli, could you start wrapping up? There's 1 minute left.
Is already permitted in terms of collective license. The exceptions that the first speaker raised are pertinent, of course, particularly in pandemic and moments of crisis. I'm talking more about the day-to-day work that we do in universities, which will have an impact on our performance assessment criteria, research funding allocations, and publication outcomes. Thank you, Mr. Chair.
Thank you very much, Professor Tomaselli. You might see on the Q&A function, while you've been talking, there have been 3 comments from Denise Nicholson. You might like to deal with them during the Q&A. I will call on you then if you want to respond to any of those comments. Yeah. Now over to you, Professor Bater.
Thank you, Judge Goldstone. Welcome, everybody. As you can see, the title of my presentation is actually hooked on a presentation or an article that I wrote just titled "Not the African Copyright Pirate is Perverse, but the Situation in Which She Lives." And what I want to do today is focus especially on the President's concerns that there has not been compliance with international law. What the President forgets is that international law for South Africa is not only copyright law, but also international human rights law. So I want to interpret international copyright law in the light of international human rights law, which is something we must do, as I shall explain. Back to the origins of copyright, we know in England the Statute of Anne of 1710 was called actually an act for the encouragement of learning. In the US, the Constitution says the purpose of copyright is to promote the progress of science and useful arts. So here we have very prominent the aspect of access apart from the aspect of a reward. Of course, a reward for the author, not so much for the publisher. A very interesting article by Jane Ginsberg, who's actually one of the authors of the very well-known commentary on the Berne Convention, where she says how copyright got a bad name for itself can be summarized in one word, which is greed. That's greed of publishers. Because what has happened in the meantime, actually, the rights of the author are actually kind of forgotten. Something that the current bill seeks to strengthen, the rights of the authors. So she says here that now copyright owners, the large impersonal and unlovable corporations actually hold copyright. And on the other hand, the access aspect is forgotten as well. Just look at the profit margins in the scholarly publishing industry, which in 10, as researched by Heather Morrison, were at 40%. So 40%, you can see the international publishers, Elsevier, was 36% in 2012, but now meanwhile at 40%. Now, if you run a business and you do your work ethically, you need a profit margin of 5%. If you have 10%, you're already very good. So we know a lot of profit is made by publishers. I'm not talking about the small publishers, the university publishers who have a difficult situation, I agree. Also look at the fact that the Competition Commission is investigating price fixing of school and university textbooks in South Africa, apparently a practice that has been ongoing since the 1980s. So artificially fixing high prices for textbooks. Looking at the royalties and license fee exports from the global south to the global north, we see where the money is going. To put it very bluntly, the poor black student in my class, by buying textbooks published internationally, actually finances shareholders in the rich countries. Going back to something Christoph Geiger, a former colleague of mine at the Max Planck Institute in Munich, has said, we need to go back to the initially dual character of copyright, which is access plus remuneration, but remuneration for the author. How do we achieve that in international law? The Vienna Convention on the Law of Treaties of 1969 has Article 31.3c. It entrenches the principle of systemic integration, which means when interpreting a treaty, so when interpreting TRIPS, when interpreting the Berne Convention, together with the context of treaty terms, we must look at relevant rules of international law applicable in the relations between the parties. This essentially is a reference inter alia to international human rights law. And let's not forget the principle of the primacy of human rights, as articulated, for example, by Olivier de Schutter of the UN Committee on Economic, Social and Cultural Rights. Actually, the TRIPS agreement in Article 7 on objectives contains this very idea. It says IP should promote the promotion of innovation. That's one aspect. On the other hand, the transfer and dissemination of technology, we can say knowledge, which is the access aspect. So it contains this element already in it, and the latest WTO pronouncements actually revert to this Article 7. Now, if we look at Article 9.2 of the Berne Convention, this contains the so-called three-step test. So the 3 steps for any limitation is only special cases, does not conflict with the normal exploitation of the work, and must not unreasonably prejudice legitimate interests of the author. This provision needs to be read in the light of international human rights law. As I say in my article that I referred to, It must be readily apparent that the three-step test must perfectly mirror the demands of human rights. Stated differently, the three-step test must permit any such use as constitutes an entitlement under human rights, and that this may differ for developing and industrialized countries. What is international human rights law? I call it the other side of international law because the president has forgotten this in his letter. It is the right to development. We know that a draft convention on the right to development is in the process. Article 4, all peoples have the inalienable right to development. South Africa as a country has this right. So, and we know that there is a close correlation between economic growth, can say social welfare, and the strength of IP protection. The duty of a country is to find it, and it may do so in terms of the right to development. If IP protection is not strong enough, there is no incentive. If it is too strong, it means progress becomes unaffordable, licensing fees become unaffordable, and we should acknowledge that the markets in different countries are different. So the ideal point of IP protection must differ from country to country. Obviously, we should emphasize South Africa is not Europe, it is not the USA. We cannot have the same level of IP protection. We must find an IP level that suits our country's economic development. Make it very vivid. The students in my IP class of 300, there are 80 white students who can afford the textbooks. The rest mostly cannot. They will have to share textbooks or try to pass without. What are the repercussions of this for socioeconomic development of South Africa? Finding the wrong balance has this result: too high a strength of IP protection means social welfare comes under the wheels. For that reason, the famous 2002 report of the EU Commission on Intellectual Property Rights states on page 104, developing countries should be allowed to maintain or adopt broad exemptions for educational research and library uses in the national copyright laws. Henning Grosse-Husekhan, a former colleague of mine who's now teaching at Oxford, at Cambridge, in his Locus Classicus on the protection of IP in international law, says that Article 7 provides countries with policy space to find the correct point of IP protection. Actually, this means, if we go back to the three-step test, there is not one three-step test. We have 191 countries. There's 191 three-step tests. This test must be applied in accordance with the domestic situation in each country. What else is international human rights? It's the right to education. Article 13 of the International Covenant on Economic, Social, and Cultural Rights says primary education shall be free, secondary education, higher education shall be made progressively free. So this means, according to the UN committee, that also the costs of textbooks are covered, and has reprimanded states for too high costs of textbooks. We also know that South Africa's prices for textbooks are far higher than comparably in many developed countries. In terms of language, very well known, the committee says that there is a right to education in your mother tongue. The committee reprimands states if there is a shortage of textbooks in minority languages. I've just prepared a editorial for a journal where I refer to this. Just think of the African languages in the South African context. Obviously, an English speaker has so much literature at his disposal, but what literature does the African student have at his disposal? So the very famous linguist Prof. Kangas speaks of linguistic genocide. And this is a term also used by William Shabas, who is one of the most renowned scholars on international criminal law. So if we do not interpret Article 8 on translations of the Berne Convention correctly, we may see the ensuing linguistic genocide also in South Africa. Which other rights? Article 15, the right to culture and science, includes the right to benefit from scientific progress and its applications. Last year, the Committee on Economic, Social, and Cultural Rights in its general comment holds a balance must be reached between IP and open access and sharing of scientific knowledge. Sharing of scientific knowledge in universities. How much do universities pay? How much technological protection measures are in place preventing access to knowledge? It is the whole topic of text and data mining, for example, which in terms of current general fair dealing is not possible in South Africa. A fair use provision would make that possible. When I was still at the Max Planck Institute in Munich, we developed what we called the balanced interpretation of the three-step test, which was signed by most renowned international copyright scholars. It's amongst others, the three steps are to be considered together. In other words, there cannot be an overemphasis on the first step emphasizing special cases. It says open-ended limitations and exceptions are possible, fair use. And it says we must look at international human rights law, going back to my premise of the Vienna Convention. Recently confirmed last year in a proposed international instrument on permitted uses, saying the same again. Look at international human rights law. This is what the president has forgotten. Fair use, is it compatible with the three-step test? Three sources that I could trace. Martin Zenfleben, one of the most renowned scholars, in his book on the three-step test, says the same questions will arise in the course of the interpretation of the three-step test as in the case of the fair use doctrine. The difference is that for fair use, we have a long history of experience which we can actually go back to, so which shows the inquiry remains the same. Pamela Samuelson says the US fair use limitation is compatible with the three-step test. But also if we look at sources like the Australian Law Reform Commission report of 2013, the second reference here, it finds fair use is consistent with the three-step test. And closer to home, report on economic contribution of copyright-based industries in South Africa commissioned from the WIPO, actually finding on the basis that the teaching exception that we have in our current copyright law is actually not possible to be used by universities, yes, by individual students, but not by universities. The publishers will charge for a single poem that is being published. So actually we have user agreements between universities and the publishers. The universities paying for something that should be free in terms of current fair use, that problem will be resolved. And also in terms of the proposed section 12D. Now here we have the three-step test in the copyright bill. You can see the emphasis on for purposes such as, and then it mentions some. Actually, this is a fair dealing inquiry with a difference that we now say the purposes are open, so making the law adaptable to future uses. And it is not just an open inquiry. Letter B says we look at certain factors, the nature of the work, the amount copied. So it is not a possibility to just copy whole works. It very much depends on the circumstances. It is very much an inquiry as we have at the present. And as far as attribution is concerned, letter C says the source and the name of the author shall be mentioned. The Australian Law Commission reform says that the problem of attribution in the case of fair use is not more difficult than in the case of fair dealing. Now, to summarize this, the case for fair use, it is flexible, technology neutral. That has been emphasized by Sanya. It promotes public interest and transformative uses. For example, search engine rendering of thumbnail-sized photographs is a transformative use. It is not a topic in the US. In Europe, it is more tricky. Fair use assists innovation, very important for us, of text and data mining, which is something which in the US is covered by the fair use clause. In Europe, not, because they have a fair dealing concept. So the European Union just had to amend its rules to make provision for that. And so it goes on. Also look at the point here, fair use helps protect right holders' markets. So this is actually a replication of the second leg of the three-step test, where we look at economic markets which may be lost. And we should not forget, at the present in South Africa, if we say that publishers will lose markets, at the present students do not buy books. With the new regulation, in certain cases where books are made available, the publishers, of course, do not get income. But the difference, there is no difference. The result is the same. At the present situation, the books are simply not bought. Going on to the education.
Could you start wrapping up, Professor?
I will do so. The last point about the copying of books, the copying of whole books, which has been a contention here in letter 3. I may just say this is an absolute replication of what we have in the Berne Appendix, agreed to in the 1970s. So this is something that we have on the international law books. It has not often been applied for various reasons. because the Berne Convention, the Berne Appendix is very complicated. But the reasons for copying whole books in certain cases mentioned here are a replication of what is in the Berne Appendix, where it is stated, for example, if books are unreasonably highly priced. This is not a situation for every textbook. For every textbook, it is a situation that may arise, where textbooks are out of print or where the owner cannot be found. But obviously, this is only a possibility after the copyright holder has been approached for license. So this is very much in compliance with international law. Maybe the last slide on translation. Indeed, the provision that is in the bill at the moment is not very well drafted. In our proposal, that I referred to the opinion that Sanya referred to, we made it much more simple. And also, this version that we propose is very much in line with what the current Copyright Act already has in it. It is just much more open in terms of purposes. And also here, remember, translation, research into neglected languages, indigenous languages, will be facilitated by this provision. My thanks.
Thank you very much indeed, Professor Barter. Over to you, Professor Dean. You're on mute.
Thank you very much for the opportunity to speak here today. As a general comment to begin with, in my view, the bill is a very poor piece of legislation. It is badly drafted. It is riddled with anomalies and inconsistencies. And so I will deal with that further in due course. My mandate is to deal specifically with the issue of fair use. So I'm going to concentrate on that issue and not spend very much time on talking about the bill as a whole. I do want to mention that my colleague at Stellenbosch University, Professor Sadula Kojika, has written what I consider to be the seminal article on fair use. It was published in the volume 2 of the 2021 Tydskrif van hier in Suid-Afrikaanse Reg. It's called Should South Africa Adopt Fair Use? Cutting Through the Rhetoric. And I really commend this article to anybody who really wants to make a proper study of the issue of fair use. Can I please have sorry, I've got the next slide already. The copyright has a rationale. It is a system for providing the creative person, the author as is the term used in the Copyright Act, with the facility to obtain financial reward as a result of his or her efforts in producing copyright materials. It has existed for centuries and has served the development of science and the arts very well. Obviously, in creating exclusive rights for authors, impact is made on the ability of the public to use the materials that are created. And so a balance must be created between the rights of the authors and the rights of the public. And this is done and has traditionally been done in copyright law by means of exceptions. Now, our Copyright Act already provides numerous exceptions. They are provided for in sections 12 and 13 of the current Copyright Act. And the object of the exceptions is to provide the balance between, as I say, the rights of the owner and the copyright owner and the rights of the public. I am the first person to admit that we need new and additional exceptions in our Copyright Act, and I don't have a problem with the fact that the bill creates such new exceptions. Whether it deals with all the exceptions that are necessary is another matter, and whether it goes too far with some of the exceptions which it seeks to introduce is another matter. Next slide, please. You've gone one ahead, yeah. Now, the Berne Convention, which is really the origin of, or the holy grail of copyright law internationally, recognizes the need for exceptions and itself contains numerous exceptions. It tests the validity or the desirability of exceptions by means of what is known as the three-step test. The provisions in the Berne Convention in this respect are echoed in the TRIPS agreement. Now, I just want to dwell for a moment on what these three tests are. The first one is exceptions should be provided only in certain special cases, and I emphasize the words certain and special. Secondly, the exceptions must not conflict with the normal exploitation of the work. You don't want to kill the goose that lays the golden egg. If you are going to deprive authors of the right to obtain remuneration from their works, you are going to kill the goose that lays the golden egg. The third test is the exceptions must not unreasonably prejudice the legitimate interests of the rights holder. Now, Klaus said that these three tests must be looked at with equal value. That's not what the international authorities say. The international authorities say, as set out by Professor Kajika in his article, that you deal with them consecutively. So the first test must be passed before you move on to the second or the third and so forth. And this puts a strong emphasis on only certain special cases. Can we move on to the next slide, please? Now, the fair use provision, which is sought to be introduced, is contained in the proposed new Section 12A of the Copyright Act. That's the section which is to be introduced. One must differentiate between fair use and fair dealing. Fair dealing is what we currently have in our Act, and that deals with certain specified cases which are set out in the legislation. Fair use, on the other hand, is a far more open-ended form of protection. It, in fact, if you boil it down to the nitty-gritty, fair use amounts to anything which a judge decides, having heard a case, is fair towards the alleged infringer of the copyright. There are certain criteria set out in the section which must be followed, but at the end of the day, it is a very wide, almost unfettered discretion on the part of the judge to decide whether, as I say, right at the end of the proceedings, so no one knows in advance whether or not use was fair. Fair use is an American doctrine. It is something which interests within America are promoting, and I say interests within America because the American government is not necessarily promoting the introduction of fair use into our law. In fact, ironically, the American government is against, is the opponent of many parts of our bill. It's an American doctrine which grew up in America. It was designed, or it is designed, to deal with American circumstances. Now, there has been much criticism of fair use. Firstly, I believe, Klaus says differently, it does not comply with the three-step test. It does not create certain specific cases. It is an open-ended system which allows for, as I said, almost an unfettered discretion. It is not even particularly well received in America. It's home country. There has been very severe criticism of fair use in America. NIMA, the leading authority on copyright in America, is extremely critical of fair use. Even Lawrence Lessig, who is one of the promoters of more freedom of use of materials, is not a supporter of fair use. So there is, quite a bit of international disfavor. There are only effectively a handful of countries in the world which have ever adopted fair use into their laws. These include, in fact, when I say include, the ones I know of are South Korea, Israel, Singapore, and Hong Kong. Efforts have been made by Interest in America to promote the doctrine of fair use. Many countries have considered it. Most have refused it. The UK, Australia, New Zealand, the EU, and Canada, for instance, have declined to introduce fair use into their law, and for good reason. The problem with fair use is that it is judge-made law. It is uncertain. No one knows in advance whether something is going to be considered to be fair use or not. You are only going to find out at the determination of court proceedings, which may go through 3 or 4 courts and ultimately end up in the Constitutional Court. So it's going to take 3 or 4 years from the time that fair use is implemented by a potential infringer before anybody, even the parties, will know whether that use was fair or not. Next slide, please. Now, I said that fair use grew up in America, and it is a system that is designed for America, and it works to an extent in America. But you've got to look at the circumstances in which it operates in America. Firstly, America has a very rigid system of statutory damages. If you are successful with your copyright infringement case, you can claim statutory damages without proving 1 iota of actual damages. And these statutory damages can vary from, in normal cases, $750,000 or $750 to $30,000. In willful cases, the statutory damages can go up to $15,000 per work. So a would-be infringer faces the prospect of having to pay very extensive damages. American litigation makes no provision for costs orders. So an infringer, a potential infringer, also has to contend with the situation that he could be landed where the plaintiff will not be obliged to pay his costs if he's not successful. There's also a well-developed system of contingency litigation. Ambulance chasing is a very common practice in America. So, in a sense, fair dealing is an advantageous system for plaintiffs, and it's a disincentive for infringers. Infringers have to think twice before they want to practice what might someday be considered to be fair use. Now, the situation in South Africa is very different. Can I have the next slide, please? In South Africa, damages must be proved and quantified. There are no statutory damages. There's only one reported South African case where damages were ever awarded, and the amount of the damages was something like 25 Rand, which was the cost of one audio tape. Never mind the 150,000 damages, statutory damages, which can be claimed in America. Defendants' costs must be paid when the plaintiff is unsuccessful. Contingency litigation is very rare in South Africa, and in intellectual property, it is almost unheard of because of the very unlikelihood of being able to claim substantial damages. So copyright holders are loath to sue for infringement, particularly when they are uncertain. Now, this means that the would-be infringer in South Africa, unlike in America, is up against it. He doesn't have the situation which exists in America. I compare plucking something out of American law like fair use and introducing it into South Africa as being similar to an invasive alien legislation, something like Lantana, for instance. In its home area, home territory in Central America, it's a perfectly acceptable type of vegetation. Its natural circumstances control its spread and so forth. Bring it into South Africa, where there are different climatic and other circumstances. It runs wild, and it's one of the worst weeds that is to be encountered in South Africa. Now, I think that will happen with fair use. Bring fair use into South African law, and it'll run wild, and it'll be like an invasive alien vegetation. Next slide, please. In conclusion, I believe that introducing fair use into our law is at odds with our Constitution, namely Section 25. Section 25 of the Constitution, the much discussed and possibly infamous property clause, prohibits the arbitrary deprivation of property. Now, there is authority for the proposition that deprivation of property doesn't necessarily mean taking away the entire content of the property. If you diminish the property right, you are also perpetrating arbitrary deprivation. Now, if you reduce the content of the copyright owner's right,
Dean, if you could wrap up, were you running out of time?
If you reduce I'll do that. If you reduce the content of the copyright owner's rights by means of excessive exceptions, you are arbitrarily depriving that copyright owner of his property. Thank you very much.
Thank you very much, Professor Dean, and thank you to all the panelists. At this point, I would like to give the four panelists an opportunity, if they wish, to comment on any of the remarks made by the others. Perhaps we can go in the same order. Ms. Samtani.
Thank you, Judge, and thank you to my fellow panelists as well. So what I'd like to do is pick up on this speculative concern that fair use is judge-made law, as well as the fact that what Professor Tomaselli raised about unrestricted copying. So I'd like to very, very quickly share my screen. I've highlighted the limits of what the CAB provides, and I've also explained exactly what we mean by fair use in the CAB specifically, not general American fair use. So so the highlighted portions, as if you can see my screen, the highlighted portions specifically indicate what the limits of this hybrid model of fair use are. So we can see here that this is not an indiscriminate anything goes model. It specifically refers to certain purposes that are listed. And what I've highlighted in yellow is what you can see are the specific factors that need to be taken into account to assess whether or not a use is actually within the ambit of Section 12AA specifically. You will see that in response to Professor Tomaselli's concern that the source and name of author shall be mentioned. So that's mandatory. You cannot simply use it without mentioning. Additionally, the substitution effect of the act on the market for the work in question is also a relevant factor to be assessed in assessing whether or not a particular use outside these purposes is fair or not. Moving then to 12D, which essentially deals with the concern about reproduction of whole textbooks, you will be able to see very, very specifically that there's a proportionality test included, 12D1, the highlighted portions, provided that the copying does not exceed the extent justified by the purpose. So that's a proportionality test, as recently written about by Professors Lionel Bentley and Tanya Applin in their 2020 book. Further, we can see that copies are specifically on secure networks only by specific people who can access those copies. And further, this is drafted in the negative that educational institutions shall not incorporate the whole or substantially whole of a book or journal issue unless they can't get access to reasonable terms and conditions of a license. So I think it's very, very clear to show and highlight the limits of this particular legislation, the CAB. So the CAB is not a free-for-all. It does not enable free copying of all textbooks for all purposes, etc. Finally, I'd just like to point out that on 12D that I just explained, several countries in the world have these same provisions drafted in similar language. For example, India, Canada, Afghanistan, Albania, Australia, China, Sudan all have provisions that relate to very similar to how 12D is drafted. And in fact, Canada has a broader provision than 12D. It's also pertinent to remember that in Peter Yu's recent article in 2019, he specifically highlights that more than 40 countries in the world have different models of fair use, even though it may have originated in America. So I'd just like to point out in conclusion that the model of fair use that the CAB incorporates is a hybrid model. So it's not fair use free for all, sort of how it's been portrayed. Rather, it's very specific. There's a specific list of purposes, and only analogous purposes can be included within that under the more general sort of fair use idea there. So I think it's important to stick to the legislation, to stick to exactly what the legislation says, and to analyze that rather than a generalist sort of version of fair use. Thank you, Judge. That's my response.
Thank you very much. Professor Tomaselli, any comment?
Yes, anything is open to interpretation, and presenting us with the actual bill is helpful. But the problem is this, is that the Coalition for Effective Copyright and the Publishing Association of South Africa have a completely different interpretation of the likely effects of this particular aspects of this legislation, where the term educational use is just too broad, as somebody has just written on the screen. The PricewaterhouseCoopers study showed a massive contraction in the South African publishing industry should these particular aspects of the bill be approved, which would result in billions of rands losses in terms of production, job losses, and as the book publishers themselves have shown, especially the university presses, is that the amount of locally generated research that gets published locally will decline accordingly. So clearly there are different interpretations. The Publishers Association has delivered a very complex or very detailed financial analysis of the potential implications of aspects of the Act. The pro-bill group has never actually engaged those figures or the Pricewaterhouse financial analysis and does not actually interact with critics of the bill when they even come in from a legal perspective. So what we're getting generally is a broad ideological argument that promotes a particular set of potential outcomes which are not actually grounded in any evidence or financial modeling. I'm saying let's look at the financial modeling that was done. We need new financial modeling because now we've had the COVID-19 problem in addition. Let's interact with each other, the pros and cons, and look at the evidence. The evidence is not being provided by the legal arguments, although particular philosophies are being provided. The philosophies are fine, but we need to look at the potential financial and industrial impacts of the bill. That's all I'm asking. Let's do some scenario planning.
Thank you. I guess it's my turn now.
Thank you, Professor Bartlett. Professor Dean, any further comment?
Well, don't you want to go to class first?
Right.
Yes.
Oh, sorry.
Okay,
I'm sorry. I left you out.
Okay. Thank you. First of all, to emphasize that there are different views today, but it is not a matter of opposing each other just for the sake of doing that. I agree with Professor Tomaselli's view that, for example, IP created by universities, technology, should be in the open domain. So I regard it as problematic that the commercialization of the universities is taking place. And in this regard, the South African government clearly has a wrong policy in the commercialization of universities. And actually, you can see that the funding of universities in South Africa, in terms of what is spent as GDP, is far less than even in other African countries. So I agree fully on that. Going on to the question of fair use in terms of South Africa. As I understand the literature, the fair use doctrine, we could just also say we are not actually adopting a doctrine from the US. We could say we are adopting a doctrine from Israel, which has imported a fair use. We have in the past adopted the sectional title scheme from Israel, and that has been very successful here. So I think it always depends on what is done with the doctrine here. It is not a doctrine of a theory as it is applied elsewhere. We know that with the introduction of the South African Constitution, a high measure of trust is put in the courts, which is very different from what we used to have. I mean, we had a fair dealing provision which comes from the UK, but we should also remember this is also not English law here. English law is very different from South African law because the courts, they distinguish cases. They do not reason on the basis of a systematic analysis, which is different from the Roman tradition which we inherited. So actually changing to a fair use doctrine which reasons does make a lot of sense to me. One further point in terms of Section 25. So we are glad that the Constitutional Court so far has not adopted a clear stance on whether the limitation of IP actually constitutes an expropriation. And it is good that it has not done so, because it should deliberate what it is going to say in this instance. I may just refer to general comment number 17 of the UN Committee on Economic, Social and Cultural Rights, because that covenant actually protects a human right to intellectual property. But
right, Professor Bart, if you can keep it short, we're going to have very little time for the Q&A.
One more minute, just 30 seconds. That committee makes it very clear that the right to intellectual property is the right of a natural person. It's not the right of a publishing company. It is the right of the author. And I think that is also what this bill is about. It is about strengthening authors' rights. Thank you.
Thank you very much. Professor Dean, any brief comments from you?
Yes, please. I'm not against adopting something from American law or British law or Israeli law. It doesn't matter. What I want to do is something that works properly in South Africa. Now, our version of fair use is no different in principle to the American system. The relevant factors for both sections are exactly the same. The only difference is that where our act spells up some examples of what, not a closed list of examples, simply examples of what could constitute fair use, whereas the American doesn't. That's the only difference between the two. It's the same system. I really, as I said at the outset, I think this is a poor piece of legislation. I don't think you can panel beat it to make it look nice. I think it needs to go back to the drawing board, and I think that it needs to be looked at by a committee of proper experts, people who have practiced IP law. I suspect that the current drafters have had very little exposure to the practice of copyright law. I would favor a new drafting committee with, I think Judge Goldstein would make an excellent chairman as far as I'm concerned. I think we need to go do it from scratch again. Why hurry something through which is imperfect? Rather do it more slowly and end up with a good product. I'm all for including exceptions for disabilities. I have absolutely no problem with that at all. The bill contains a number of good things. The real problem is how it is expressed and the legal tightness of the legislation, which I think is seriously problematic. Thank you.
Thank you very much, Professor Dean. We have a number. There are many comments in the chat column and in the Q&A, and I'm going to restrict. We have 30 minutes for question and answer. I'm going to begin with what are really appear to me as questions. A very early hand up was from Makira Batsua Mupela. Do you have a question? No, it seems not. Then there was one. The The first question in the chat column came from Carlo Lavazzari. His question is, where does Google and big tech pay their taxes? Perhaps nowhere, but hardly in the LOCs. And he added, the shrinkage of the Canadian publishing industry and its subservience now to US publishing is beyond dispute. The Canadian Copyright Act, which compares rather as mild when read side by side with the defective bills here, was a direct cause. Anybody who would like to respond, particularly on the Google question?
I can just mention that, as I've said when I spoke earlier, the American government doesn't favor our bill. So to the extent that it incorporates American principles or practices, the Americans don't favor that. Where the impetus has come for many of these very widely expressed exceptions and fair use in particular is from American business interests. The Googles and so forth of this world, they are the prime promoters of this bill. And one has to ask why. It suits those sorts of organizations to have free access and have to pay no royalties for use of anything that they put into their libraries.
Thank you. Then I can move on to Ashraf Patel. He says the copyright bill should be viewed in context of other legislation such as DTI's Industrial Policy, DSI's Patent and Indigenous Knowledge Bill, and the DSAC's Performers Bill. All of them have major implications for livelihoods and innovation, and the UN's right to development. Large multinational corporations, especially Google, are dominating these policy debates. Do we have a countervailing public oversight and policy sovereignty? Professor Baite?
Thank you for that question. Actually, it also reverts to the question we just had about the problem of Google and these kind of companies. The problem here, I think, does not lie in the field of IP law, but in the field of taxation. And that is why at the global level, there are now endeavors to formulate a framework for the taxing of these organizations. So Google would, in every country where it operates, have to pay taxes, and profit shifting is the big problem of our time, and that is to be resolved. And these taxes, and I know the literature, these taxes would amount to millions. This is the money that would also be needed, for example, to nurture a local publishing industry in this country, or to support the university publishers. I fully agree with Professor Tomaselli, how important they are. So that would be my response to that question. And perhaps also on the question of the US resisting fair use in South Africa. We know that the US also resisted parallel imports for very much needed medicines in South Africa, leading to many HIV deaths here. So I would not rely too much on the position of the US government here.
Thank you. Then Valmont Lane says, could I ask panelists to comment specifically on the potential benefits, stroke impacts of the amendment bill may have on research archives and collections where unpublished records are held, as opposed to libraries as such? Yes?
Just to say that although the specific provision 19C of the bill does not mention unpublished manuscripts or unpublished materials in general, there is a general provision at the very end of 19C that specifically reverts to 12AA, which I showed you previously, which essentially deals with fair use. So your unpublished manuscripts will be protected because they are analogously protectable to the published manuscripts. This is why we need these sorts of broader provisions in order to take into account things that people working within these institutions believe to be important, that people working outside of these institutions did not contemplate.
Thank you. Then there's Warren Klippe said, I agree with Professor Dean that the bill is a bad piece of legislation. There's no use replacing the current act with a badly drafted bill. My understanding is that the bill has not even been subjected to the socio-economic impact assessment study. We can't push through legislation willy-nilly. Is the assumption correct? Was any comment on that? Professor Dean? All right, well, I wonder if I can get some help from the technical people. I've had a note that there are two people have their hands up. I'm not sure how to deal with that. Are there people with hands up who want to be have their videos on?
Can you hear me? Hello? Hi. Yes. Judge, sorry.
Judge, sorry.
Yeah.
Yes, just for orderly sake of things, we have unmuted Tebogo and Kyla. Could you please ask one of them to actually ask the question? Thank you.
Right.
Thank you.
Okay. Can we start with Mr. Mupela?
Tebogo has been raising his hands from the first minute. How are you, Judge? Can you guys hear me? Leonard Friends?
We can hear you.
Okay, how are you?
Good, thank you. What is your question?
Yes, I was starting to be worried that you're talking to yourselves as Leonard Friends. Well, my comment is just a quick one. It's a pity now we're going to be under pressure of time. But we've listened to the presentations. I smell that there's so much hugely vested interest from most of you as presenters. And I think it's a bit disingenuous and slightly disrespectful to think that, you know, the people that worked on the bill were not smart enough. Like the comments I'm hearing that is a badly drafted piece of legislation. So I think from you, Leonard Friends, help us as a country. I'm a creative. I'm not a judge, neither am I a lawyer, but I respect you, but I don't think you are helping us. Help us understand what is right in this bill so that we can fix it. Because in the meantime, whilst you're squabbling,
I'm sorry to interrupt, but can you put a question?
No, can I finish, Judge? You see, that's the problem because you are now pressurizing us to have like I'm not English speaking, so I'm trying to get my thoughts together. So we creatives are dying as paupers. Disabled people are actually suffering. This is an unconstitutional bill. I think if we had pushed this bill and start to deal with other issues that everybody may have, with no piece of legislation is perfect, I think we would be somewhere. Now, right now, we have to start from scratch. It's not right. But I think the question directly to Dr. Owen Dean, whose property is this anyway? Expropriation of property. The property that we talk about, particularly in the creative world, begins as property of creatives. It gets owned by intermediaries. And then guess what? The very creators of the property suffer, they die with nothing. So I think you need to tell us whose property is it anyway? If the US has got fair use, why can't we have it? Let's not be scared to go into uncharted waters. We've got to start somewhere. Let me stop right there. Thank you very much.
Thank you very much. Any response from any of the panelists?
Yes, I'd like to answer that.
Professor Dean?
The property conferred by the Copyright Act is conferred on authors. Authors are the keystone of copyright law. What often happens, unfortunately, perhaps unfortunately, is that assignments of copyright take place and then publishers and those sorts of people enter the picture. But that, in a sense, is up to the author. I mean, no author is compelled to assign his copyright. As long as you don't execute a written document which transfers the ownership of your copyright to someone else, you remain the author. And if I'm correct in saying that aspects of the bill can lead to arbitrary deprivations of property, it's the property of the authors which is being deprived. That is the root of it. That's where it all starts, with the author.
Thank you. Any further comments? If not, I have only one last question that I can find on the Q&A from Hette Pieterse. She said, please comment on the lessons learned by Canada and their testing of fair use and the detrimental effect it had on their local industry. Anybody can comment on the Canadian experience?
Judge?
Yes, so Sonia?
Yeah, this is not specifically on the Canadian experience, but this is more specific to the CAB and what the CAB does to prevent damage to the local industry. So in the provision that I demonstrated, that I put up previously, that provision on the copying of textbooks specifically, so that's a specific type of work, there are only 3 circumstances where that's possible. The first is where that textbook is out of print, which means it's no longer being published. And so there's no detrimental effect on the publishers, whether international or local. Secondly, we've got the provision that where the owner of the copyright cannot be found, which means that the person seeking to utilize or to copy this textbook must find the owner of the copyright, the right holder. So there must be reasonable efforts made to do so. And finally, and this is the most important thing that actually responds directly to the question on local industry, specifically says that where a particular edition of a textbook is unavailable in the South African market, only then can it be copied, etc. So it doesn't affect the local industry specifically. And therefore, it's I think the speculation that is sort of inherent in the question that it would be to the detriment of local industry is misplaced.
Thank you. I've just noticed there was a question in the chat column from Koen van Wyk. He said, question to the panelists, given the exorbitant cost of any legal action, what relevance does the legislation have to do with ordinary people who can never afford instituting action? I think this applies not only to patents, but across the board. Any response to that? Professor Dean?
There are provisions in the bill which create a commission, which presumably will, it seems as though it's intended to be some sort of fairly easily accessible court. And I use the word court in inverted commas. This particular section is one of the sections which I think is particularly prone to uncertainty and bad drafting. For instance, it's not at all clear exactly what the functions of this body is. It's not clear to me whether it's intended to deal with infringement matters or not. If it is intended to deal with infringement matters, it's certainly not specified that it's entitled to award damages. So it's a very incomplete form of dealing with infringement. It also introduces a total anomaly into South African law in providing that the proceedings must be done on an inquisitorial basis, which is totally at odds with the way every other dispute is handled in South Africa. And so it really comes back to the point that I don't believe that the people who drafted this act had great insight into the practicalities of copyright, into practicing copyright law. I feel that the copyright is a bit like bridge or chess. You can read all the rules, you can sort of swat up all the theories, you can have all of that at your fingertips, but you don't actually acquire expertise in playing the game until you actually play the game. And when you conduct or you're involved in copyright litigation, you get insights into how these provisions can work and what they really are intended to mean. And I believe there's a total absence of that sort of insight into the drafting of this bill.
Thank you. And then I have a message that Carla Jade has a hand up. Would you like to ask your question or comment?
Yes, thank you, Mr. Goldstone. Before I ask my question, I just want to also quickly respond to 2 things. Firstly, regarding the PwC reports, I do know that one of the things I know is that the lawyer Sean Flynn did write about it, and he critiqued it because it was essentially a survey of executives at publishing companies, and he did a number of points about it and critiques. And then also the situation with Canada. I know that there has been reports on it about the fact that the decrease has also coincided with the emergence of the digital era. So a lot of universities have, been relying more on blankets, digital licenses, and stuff like that. Not to say that there isn't an impact of the focus of, the use of education and fair use, but there's also a lack of integration of understanding how all of that also is connected to the emergence of the digital era. But what I want to say is, and ask, is kind of echoed to what Tebogo was talking about. And that is that a lot of the time with these conversations, it really, even though they talk about copyright holders, there's this important difference between a creator and a copyright owner. And I think a lot of the time we end up in these echo chambers of people who are representing the intermediaries, the big multinationals, the big publishing companies and all that type of stuff and their interests. Whereas there's this really lack of reckoning with the fundamental interests of the people on the ground, the actual creatives, the actual communities that are affected by our copyright law. And it's so important that we integrate these. And if, a lot of these academics and copyright legislators and stuff say that, okay, well, they don't know what they're doing, they don't know the practical implications of this bill and whatever, then there should be more of an effort to work with the government, work with communities, work with stakeholders to actually improve our current legislation. Because yes, we actually do need to hurry this legislation. Yes, we actually do need to implement this because people are literally dying, unable to access healthcare, etc. So it is urgent. And my question is, why aren't the people who are involved at this level, at an academic level, who seem to have all the answers, why aren't they doing more to work on the actual bill, as Sanya is doing, and we're doing more to work with actual communities and actual stakeholders and the government, as opposed to just being mouthpieces for intermediaries? Because while that's great, we should obviously protect all these stakeholders, we also need to, this is urgent, we need a reform, copyright reform. Our legislation is from 1978. So much wasn't even invented back then. So I just want to know, why aren't they doing more to reckon with the actual bill and with the needs of our people?
Okay. Anybody want to respond to that question?
Yeah, I can respond, Mr. Chairman. I think that, many people and organizations across all expressive sites in this country have been working on this bill, plus also the Performers Amendment bill, debating these issues, looking at the contradictions, trying to work out what went wrong, how to get it right. There have been meetings, there have been workshops, there have been webinars, thousands of pages of critique have been sent on to the portfolio committee. But the people who want to who recommended some revisions of aspects of the bill, particularly the elements relating to the very broad notion of education, have not been listened to. And this is one of the reasons why we're sitting here debating, sometimes from different positions, because we can see different outcomes given different interpretations of what might actually come to pass. So to say that nobody's actually been involved in this is wrong. Thousands of, hundreds and hundreds of organizations and people have been involved in trying to debate these issues. And that all comes down to a badly drafted piece of work that needs to get properly written. If you have a bad law, you can't implement it. It's simply going to get thrown out. And to take it to the Constitutional Court will be extremely expensive, and there will be further delays. For example, Professor Dean has given a very elegant solution to the question of disability rights, but nobody follows that up. No, it'd be an exception to the current act. Why are we trying to sort out the remaining contradictions for the rest of the act? It's just a question of writing and making sure that things are clear. That then helps us to plan for the future. you know, I could go on, but you know, there's thousands of pages written about this bill that can be accessed by anybody. It's all on open access.
Thank you very much. And Carla Lavazzari, you have your hand up. Lavazzari, are you there?
Hello, can you hear me? Thank you, Judge. Yes, I wanted to ask the panel about the interaction of fair use in 12A and, for instance, 12D, where whole books may be copied if the copyright holder does not offer a reasonable license, which sounds reasonable enough. However, that provision masks that short of copying a whole book, taking perhaps only 80%, would then be permitted. So with an exception that broad, wouldn't fair use have to be interpreted as even broader to be given any additional meaning side by side with these very broad exceptions? Thank you.
Thank you. Professor Botha.
Thank you, Judge Goldstone. The current Act has a fair dealing provision which covers research. The problem is there's a lot of uncertainty concerning it, and universities do presently not really rely on it to make available any information. I would just like to refer to the apartheid era, where I was privileged as a white person to study, and where universities used to regularly make available copies of articles in readers. So this was a practice at a time when it was perhaps not that much needed. Now it is much more needed. But this fair dealing provision causes a lot of uncertainty because it should also be available to universities. That is what Section 12D provides for. It only makes that point clear. When it comes, it leaves intact the normal inquiry. Your copying must not exceed what is justified by the purpose, and so your dealing must still be a fair dealing. That remains intact. It is only a clarification of that point. And as I said, the Section 12D is an integration of the Byrne Appendix into South African law, and it would only allow the copying of whole books in very limited cases. Section 12A is a general provision, the fair use provision, keeping open the option for potential cases that might arise that cannot be covered under the other provisions. But the inquiry for fair use is very much the same as in the case of fair dealing. It is as limited. The only difference is you have a such as. Purposes are left open.
Thank you very much. And we'll have a final intervention from Professor Schonwetter. Professor Schonwetter?
Sorry, it's a bit tricky. I was trying to unmute myself and then I was muted again. So I think there was a bit of muting tennis going on. Thanks for giving me the floor. This was excellent. The last 2 hours or so. I just felt that towards the end we were just getting back into this pattern of re-raising issues that have long sailed. What is before us really are a limited amount of issues that still need to be discussed as raised by the President. It is no longer really a question as to whether certain exceptions and limitations will form part of this. I think many of the flaws or suggested flaws are no longer on the table and are not considered by many other commentators, including myself, as flaws of the bill. I think actually what is before us is a pretty decent piece of legislation to work with. I guess my question, and I had put it actually into the Q&A, and I saw some more questions there as well, is one for specifically for Professor Dean, because I didn't feel that this was sufficiently substantiated, because he was maintaining that fair use is indeed in violation of international copyright law, international copyright treaties. We heard some arguments against that argument put forward by Professor Botha. And I want to just second these arguments, in that really there is hardly anybody around the entire world who maintains anymore that fair use is indeed in violation of the three-step test and international copyright law. Those who have been previously skeptical have changed their mind. There have been long inquiries, in particular by the Australian Law Reform Commission in 2014, that was which was exactly addressed with the same questions. 900 consultations later, 100 consultations with stakeholders later. Much more what we are able to do here within these 2 hours. The conclusion of the Australian Law Reform Commission was it couldn't be any clearer. Fair use provisions are not in violation of international law in the three-step test in particular. And I'm yet to be, and the Max Planck Institute has put something similar forward. A lot of other commentators that I could mention here, but I'm just puzzled by how this argument could still be raised, continuously being raised, whereas there seems to be almost anonymous kind of support of fair use in line of international treaty obligations. Thank you.
Thank you very much. Professor Dean?
At the outset of my talk, I referred to what I consider to be seminal article written and published by Professor Sadula Kajika on the whole issue of fair use. He certainly reaches an entirely different conclusion to Professor Schoenwetter. On the contrary, he says that it is the preponderance of international opinion is that fair use does not comply with the three-step test. And the only reason why it hasn't really been addressed squarely is because of America's economic strength, and there is a reluctance to take on America on this issue. But I really suggest to Professor Schoenwetter, or Dr. Schoenwetter, as well as anyone who's interested, take the trouble to read Professor Kajika's article. It sets out the whole issue. He makes the point, and it's a very valid point, that nobody in South Africa has ever come forward with a rational, documented approach as to why we should adopt fair use. It's just slid in somehow without it ever being properly promoted by anybody, properly motivated by anybody. Thank you.
Well, thank you very much. I think we've come to the end of the webinar. I'd like to really thank the Academy for having organized the webinar. The dialogue has been important and very interesting, and I think this is the interest is certainly indicated by the large number of participants in this webinar. For concluding remarks, I'll hand over to Professor Gledhill.
Thank you very much. Before I make a couple of concluding remarks, I have a rough patch to get over personally. I confess I've put myself in an embarrassing position by not realizing that I should have introduced you, Judge, right at the beginning.
Please, don't take it any further, and it's not necessary.
Oh, thank you very much indeed. Okay, so let me go through points that I, as a physicist, have collected on the way through. First of all, the comparison between the current Act and the CAB, the CAB, touches on the points of bringing laws into line with the Constitution because the present status quo is unconstitutional. Secondly, there is the important discrimination that still persists through our current law against people living with disabilities, the book famine, the device shifting problems. There is the incorporation in the bill of text and data mining technologies, and I think that these are all not contested in our conversation here. The inclusion of recording and software, similarly, the inclusive use list that includes the controversial phrase such as for future-proofing purposes is, however, near the heart of our discussion. We don't at the moment have in our law use allowing mass digitalization to preserve our cultural heritage. And we do need to address the distinction between authors and their intermediaries. In terms of IP rights being transferred beyond the current market or scope, this is one of the points that needs engagement at the moment. So I will list some of the points that need engagement. There is a considerable concern about the impact of funding, especially DHET incentive funding. There is concern about the threat to local publishers and whether there is such a threat, and the distribution of royalties, the correct access to royalties, especially to Indigenous publications. There is considerable concern about inadequate local resourcing, and I would add to that the financial situation of government and fiscal constraints in the coming years, which it forms the background to that. Then there are a number of concerns that need to be addressed under open access and open science. I think the concern about the potential shift of paywalls from reader to author, the economies of scale lost through article processing charges, and the significant impact on the organizations and universities of funding and the redeployment of research funding. Then there is a significant concern that big tech companies will harvest work placed in positions of access or thought to be unprotected. In terms of our international context, we see the human propensity for greed, which can be exercised in such a way that the rights of the author are forgotten. This is a big concern. Copyright has two aspects in access and remuneration, and human rights govern both. They are at the foundation of those. The balance between intellectual property rights and social welfare needs explanation in this case. And I think that it has emerged that access to textbooks is a good test case for these. The three-step test that arises from the Berne Convention and the TRIPS agreements on special cases, on conflict with normal exploitation, and we're not sure what normal means these years, and no unreasonable conflict with legitimate interests of the rights holders, certainly needs explanation. Fair use is at the heart of this debate. And again, the purchase of textbooks is a good test case. New additional exceptions might be considered. There's a significant concern that with the bill as it stands, fair use would rely on decisions of the court. And the decision is made after proceedings have been initiated. And there's a big concern that guidance will only develop through building up case law. We certainly can use and recognize, be informed by international experience in fair use, but the nugget of the whole thing is the South African context, the issues of do we have the same environment for statutory damages, costs orders, contingency litigation, and who does the advantage lie with in our South African law? We need to establish whether fair use is constitutional. And I think I would say that a transition is implied by the fact that the Copyright Act is so old and that the Copyright Amendment Bill comes so many decades after it. And that transition implies has implications for the regulations arising from this bill, the many stakeholders involved, and the significant effects on them. We need, as quick notes, to examine the interests of who benefits from the new bill, the fluid state of global views of taxation, whether unpublished material is protected or not, the socioeconomic study background, whether that has been made available, expropriation of property. I would direct your attention to the data and cloud policy recently published in the Government Gazette, and whether property conferred on authors is assigned under pressure in the community of practice. So this amounts to a call for clarity, among other things, and finally, the call for practical work on the bill to take into account the balance of benefits of stakeholders in South Africa. I would ask you to submit comments through your invitation to this workshop by the 9th of July on the 6 comments of the President as circulated, and continue to engage through ASSET. Judge Coldstone, may I hand back to you for a final word?
Right. Well, I've got very little to add except to again thank the panelists for their excellent presentation, and also to thank all of the staff at the Academy. A lot goes on behind the scenes in organising these webinars, so my grateful thanks to them. And one final comment: any submissions have to be, and as has been stated, by the 9th of July. But please note that it's 12 noon on the 9th of July, not later than that. Thank you very much. And with that, I close the webinar.